motion, John Howell.
Thank you, Mr. Speaker. I beg that leave be given to bring in a bill to limit the grounds of appeal against decisions on planning applications that are consistent with a neighbourhood development plan and local plan and for connected purposes. I am moving this bill today to try to provide reassurance to those communities who spend considerable amounts of time and money producing a neighbourhood plan, that their work is valued, that it plays an important part in the planning system and in the determination of planning applications, and that together with the local plan produced by the district or borough council, it is a fundamental document.
Order. It is something of a discourtesy to the honourable gentleman, the member for Henley, who is moving his 10-minute rule motion. It might not be front and centre stage in the minds of all honourable and right honourable members, but it's extremely important to the honourable gentleman and to a lot of people. And whether people are interested in listening or not, they should do the honourable gentleman the courtesy of affording him a respectful silence. Mr. John Howell.
Thank you, Mr. Speaker. That it is a fundamental document and that the effort made in producing it is worthwhile. In my own constituency, 2 more neighbourhood plans recently passed at referendum by 94% and 98%, showing how much they are valued by communities. This bill is to show that where a district and parish have taken control of the planning requirements of their area, that view is an important and determining one for taking applications forward. I do this having held the position of government champion for neighbourhood planning, and in that role I have been around the country talking to groups of parish councils and their members of parliament about why they should produce a neighbourhood plan. I'm grateful for the large number of colleagues who have supported this bill, far more than the 11 supporter slots available. In my own constituency, at a village called Sonning Common, the local community and district council are reported to have spent £90,000 defending the village's new neighbourhood plan against an appeal. The subject of the appeal was an application for 95 dwellings on a site located in the neighbourhood plan for just 26. Why this application was able to be taken to appeal is part of the reason for this bill. The application was inconsistent with the Sonning Common neighbourhood plan, and there were no mitigating circumstances otherwise. Local residents had worked very hard on the neighbourhood plan and indeed continue to do so. The question we have to ask is, why was the existence of the neighbourhood plan not sufficient? In order to set the scene for this bill, let me go back to what prompted me and the then Minister of Planning, the Right Honourable Member for Tunbridge Wells, to introduce neighbourhood plans in 2011-12. The starting point was the recognition that the previous system of taking parish views on applications into account by ticking one of 3 boxes was inadequate. The boxes were yes, no and no firm opinion. As we live in a plan-led system, it was crucial that anything that replaced it was part of the plan-led system, hence a new plan, the neighbourhood plan. This has proved to be a much better way of crystallising local views of development. The neighbourhood plan becomes part of the local development plan when it is approved at referendum and thereby carries the full legal weight that the local plan does. It is not a NIMBY charter. The plan needs to conform with the strategic objectives of the local plan, particularly the housing numbers, which should be seen as a minimum figure, and they have in practice allocated some 10% more sites than originally detailed by the district or borough council. So far, around 2,500 communities around the country are producing a neighbourhood plan. A high number have already passed referendum, with North Korean-style majorities. Despite the work of the local plan expert group on which I serve, wanting to simplify the production of neighbourhood plans, it is a process which is becoming more complex and time-consuming for ordinary people to carry out. And I pay tribute to the volunteers who spend so much of their time putting these plans together. But there is a bigger problem with this which this bill seeks to address. Let me explain. Imagine you are a parish which has committed money and considerable amounts of time to producing a neighbourhood plan. You have been through the exercise of allocating sites. You may even have allocated more than you were told was appropriate by the district council. A developer wants to make a planning application which falls outside of the neighbourhood plan. He makes that application. It is rightly refused as being not in accordance with the neighbourhood plan, yet he is still able to put in appeal to the planning inspectorate. That appeal will need to be defended. It will require vast amounts of time from local people who put the plan together. It may require the services of a QC. It may require the services of other specialists depending on the nature of the defence. Like at Sonning Common, they and the District Council may end up having to spend around £100,000 on defending it. However, the chances of the neighbourhood plan being upheld are open to doubt. In other words, all that effort and all that money could be wasted. The question I'm always asked is why, when we have a neighbourhood plan, should the developer be allowed to make an appeal? So how does this bill work? Let me give 3 examples. First, we have the situation where there is a robust 5-year housing land supply in place, or indeed, where appropriate, a 3-year housing land supply, and a fully approved neighbourhood plan and local plan. In this case, a developer makes an application for development which is contrary to the neighbourhood plan and is earmarked for refusal on the basis of neighbourhood plan policy. In making its decision, the local plan authority decides first that the application is outside of the plan or contravenes a policy in it and refuses it. It also makes a formal decision which is published as a formal notice in the minutes of the Planning Committee that the application is contrary to the neighbourhood plan. In other words, that the neighbourhood plan holds sway. In this case, the developer would have no right of appeal, which would be withdrawal. In the second case, there is still a 5 or a 3-year housing land supply, but in reaching its decision, the local planning authority does not follow due process. It takes a decision about which there are legitimate processual errors. It is not possible to evaluate the significance or impact of those errors and whether that would ensure that the decision can be overturned or whether it would make no difference at all. In this case, too, the finding of fact is the application is contrary to a neighbourhood plan. In this case, the developer would have to make an initial referral to the courts by way of judicial review of the processual issues, meaning that the bar for a decision was a high one in which he would seek leave to appeal to the planning inspector. It would be for the court to review the processual errors rather than the issue of fact. Finally, in the third example, there is no 5 or 3-year housing land supply in place, but the local planning authority still refuses the application. In this case, the rights of the developer to appeal the application to the planning inspectorate would continue as now. The effect of this would be multiple. First, it will send a strong message to developers that neighbourhood plans are to be taken seriously. I'm fully aware of one developer who has devoted considerable resource to undermining neighbourhood plans and regularly puts in objections to local planning authorities. The issuing of a notice by the local planning authority makes it clear that there is a finding of fact that the application is contrary to a neighbourhood plan. Second, it is only by doing this that we will return real democracy to towns and villages of this country as we originally envisaged in the Localism Act. It will have no bad effect on the housing numbers. As I said, neighbourhood plans provide for some 10% more housing than originally envisaged. It could even make it more attractive for towns and villages to allocate land for more houses, knowing that they will be protected from rapacious interests. Thirdly, it will also give towns and villages confidence that producing a neighbourhood plan is worthwhile and will be seen as producing a determinant for the planning system. Lastly, this can be seen as another step in the reform of the neighbourhood planning system, which has adapted to changing circumstances throughout. First, there was the Barwell ministerial statement, which reduced under certain circumstances, the housing land supply to 3 years. More recently, it has included changes to simplify the process for updating a neighbourhood plan. Lastly, it will encourage communities to prepare plans, including local district and borough councils, and to support neighbourhood plans. In the local plan expert group, we quote the then National Planning Policy Framework, that plans, and I quote, should be the key to delivering sustainable development that reflects the vision and aspirations of local communities. But we also commented that less than a third of the country was suitably covered. There are many examples of good practice in plan making. this bill adds to that stock of good practice.
The question is that the honourable member have leave to bring in the bill. As many as other opinions say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
Sir Oliver Letwin, Sir Nicholas Soames, Sir David Evanet, Nick Herbert, Sir Geoffrey Clifton-Brown, David Hanson, Kevin Hollingray, Gillian Keegan, Victoria Prentice, Damian Moore, and Stephen Lloyd, and myself, sir.
As far as he could.
He did, yes. Well, he does always sit there. He wasn't being contrary, that's where he normally is.
John Howell.
Planning Appeals Bill.
Second reading what day?
Friday, the 25th of January, 2019.
Friday the 25th of January 2019.